welcome to the latest Radcliffe Chambers Junior Programme commercial. I'm Alexander Kingston-Splatt. I'm a commercial chancery barrister here at Radcliffe Chambers, called in 2017. My practice is in commercial litigation, civil fraud and insolvency, and I'm ranked as a rising star for insolvency by Legal 500. With me is Robert Lee, who's a commercial chancery barrister who completed his pupillage at Radcliffe Chambers last October. And we'll start with Robert's talk about late registration and so on of company charges. And then
Thanks,
I'll talk about my part of the talk afterwards.
Thanks, Alex. I'll just get the slides up. Morning, everyone, and thanks for the introduction, Alex. I'm Robert Lee. I'm a barrister here at Radcliffe, and today I'll be speaking to you about late registration and rectification of company charges. So first thing I want to look at is just what is the purpose of registration. So Section 859H of the Companies Act indicates what the consequences are of a failure to deliver particulars of a charge to the registrar. So where the charge has not been delivered to Companies House, that charge will be void insofar as its security on the company's property as against liquidators, administrators, and creditors of the company. Subsection 4 of Section 859H clarifies that there is still a contractual obligation will still subsist between the parties, but the consequences of the charge being void are that the money secured under that charge immediately become payable. So the contractual remedy remains, but the benefit of the security is largely lost as against those parties. So the consequences of non-registration are very serious. So this talk, I'll proceed under 4 headings. Firstly, I'll look at the legal framework that applies. Then I'll identify some of the possible issues that can arise in this area. I'll then look at a couple of example scenarios with possible ways of dealing with those scenarios. And finally, I'll look then at the practice and procedure of the court when dealing with these claims. So basic principle, Section 859A, charges created by a company, the particulars of the charge, along with a notice called an MR01 notice containing the details of that charge, should be delivered to the registrar. And that must happen within 21 days, beginning with the day after the date of creation of the charge, unless an order is made under Section 859F, which we'll come to in a moment. So the period of 21 days is quite a short one. You'll have execution and delivery of the charge, and you've then just got a 21-day period for those particulars to be delivered to the registrar. And once that's done, then registration can take place. However, what we'll primarily be focusing on today is what happens if there's some issue regarding delivery within that time frame, or some issue arises subsequently. So Section 859F provides that the court may extend the period of time allowed for delivery. The requirements for the court to grant the extension are given in subsection 2 of Section 859F. The court may make an order for an extension of time provided that the failure to deliver the particulars was accidental, not prejudicial, or that on other grounds it's just inequitable to grant relief. In practice, you'll usually be issuing the claim under all or at least 2 of those headings, because the subsection B of subsection 2, other grounds it's just inequitable to grant relief, that will apply in most scenarios. Subsection 3 then provides that the court may, on the application of a company or another person interested on such terms as the court thinks just and expedient, may order that the period allowed for delivery be extended. Now, that would appear to give the court a very broad discretion as to the conditions attaching to an extension. However, we'll come to it a little bit more under the practice and procedure, but in practice, the court considers that there seems to be a kind of consensus view that the court's only permitted to extend time by a further 21 days from the date the order is made. So it's not at least it's not exercised in practice as a discretion to extend for a longer period than the 21 days as would apply under ordinary circumstances. Section 859I provides that in the case of registration, the certificate of registration will be conclusive evidence that the documents were delivered to the registrar before the end of the relevant period. So I'll come to this in the examples again, but this actually leads to some strange results in practice, but we'll come to that shortly. Section 859M applies to omissions or misstatements in the notice that's delivered to the registrar. So usually that will be in the M or 01 notice. If there is an error there, section 859 allows the court, 859M allows the court to order rectification of the register to correct any errors in the notice, the MR01 notice in practice. Section 859N, which is the second last part of the legal framework, provides that if the wrong instrument or debenture has been delivered to the registrar, then effectively the court can order that there's a swap such that the incorrect charge is removed and it's replaced by the correct one. We'll come to examples of how that can happen in practice. I think usually what happens is there's been back and forth of various versions of the instrument. A final version is then executed. However, the wrong version is then delivered to the registrar by one of the parties' solicitors. So this section allows for the court to make an order for the removal of the incorrect charge and replacement with the correct one. Finally, then, and moving beyond section 859 area, you'll see section 1096 provides for rectification of the register under court order. And this doesn't apply specifically to charges, but the registrar shall remove material which the court has declared to be invalid or ineffective, or to have been done without the company's authority, or that the court declares to be factually inaccurate. Notice there subsection 3 provides that the court may only make an order for the removal from the register of anything which has had legal consequences only if it's satisfied that the interests of the company or the applicant outweighs the interests of other parties. So that will usually require some witness evidence. The distinction here between section 1096 and section 859N is this can be used for simple removal, whereas section 859N will be for removal and replacement by a different instrument. Moving then to the second part, some possible issues which can arise, and these are probably in order of how common these issues are. So the first issue could be failure to deliver the particulars within the 21-day period provided, therefore an extension is required. Another issue would be there's an error in the MR01 statement of particulars that accompanies the charge, and that needs to be rectified. Third possible issue is wrong charges registered, for example, an earlier version which the parties had amended prior to execution, but which was then actually delivered as the purported correct charge which the parties had executed. And finally, a charge is wrongly registered or registered without authority. So these are some of the issues that can arise. And we'll now look at some example scenarios and possible remedies in each of those. So example 1, borrower solicitor with conduct of the matter goes away after creation of the charge, neglects to delegate the task of registration to a colleague. The solicitor then returns and attempts to deliver the particulars after the 21-day period. That's then rejected by the registrar because the particulars have not been delivered on time. So the issue is an obvious one, particulars not delivered within the 21-day period. So looking then at what the remedy would be here, the remedy would be to issue a claim pursuant to section 859F for an extension of time to register the charge. That claim could be, depending on the exact circumstances. In the example I've given, it sounds like inadvertence, and in any event, it would be just and equitable to grant relief on the basis that the lender's security would be prejudiced otherwise. So that's kind of the most straightforward scenario, and we'll come to, under practice and procedure, exactly what form the claim takes, but broadly speaking, it's under section 859F. Second scenario then, charge created 1st of March 2024. MR01 incorrectly states that the charge was created on the 21st of March 2024. The particulars are then delivered on the 31st of March 2024 and accepted, and that's accepted by the registrar. So we have seemingly two issues here. The first one is there's incorrect information on the MR01 relating to the date of creation. And secondly, the charge has been registered out of time because more than 21 days have elapsed between creation and registration. So two issues. However, you'll recall what I mentioned about section 859I. In the case of registration, the certificate will be conclusive evidence that the documents required were delivered to the registrar before the end of the relevant period. So therefore, there's no need for an extension of time. All that's needed is an application under section 859M to correct the error in the notice. So there's no need to extend time because we've got conclusive evidence that the documents were delivered on time, even though we know as a matter of fact that that was not the case. So it's a somewhat strange outcome, but that's how it's treated. Third scenario, then, there have been various versions of the charge exchanged and amended prior to execution and creation of the charge. As a result of inadvertence, the borrower solicitor delivers an earlier version of the charge, which is accepted, and the error is then identified after the 21-day period for delivery has elapsed. So the issue is that the incorrect charge then appears on the register. So firstly, you might say how this arises. I think in practice, what sometimes happens, and it's not best practice, would be the parties simply execute the signature page without having the whole charge there at the same in the same document, essentially, and they then just append that to what has been agreed. The other thing that can occur is the parties may have just made small changes. The parties then execute what they think is the final agreed charge, but they then realize that this was an earlier version and not the correct one. So how to remedy that then? Apply under section 859N for an order that the instrument which is there is removed and that it's replaced with the correct charge. So again, a rectification claim. Final scenario then, a charge is signed by an individual who purports to act for the borrower company. That charge is registered and the company then becomes aware of the charge which has been registered without due authority. So let's say fraudulent or signed by someone in the company who has no authority to bind the company. So the issue here is that there's a charge in the register without the company's authority. So remedy in this scenario would be to apply under section 1096 of the Act to rectify the register. As the registration has had legal consequences, we'll need to show that the interests of the company outweigh the interests of other persons. So those are some examples, and I'll now move on to some procedural points to note. So looking at pre-issue then, you'll see the practice direction states that the usual place of issue of these claims is now the County Court at Central London. Proceedings can be issued under Part 7 or Part 8 as appropriate. Invariably, in my experience, these are Part 8 claims. Interesting question then on whether the registrar should be added as a defendant. There is no clear rule given in the Act as far as I'm aware. However, Practice Statement 49 states that it's strongly recommended that the registrar is added as a respondent and served with the application in claims under section 1096. Companies House Guidance states something similar. The distinction in practice appears to be between where the registrar will be required to do something more than simply registering the charge. So if you've got a claim simply under section 859F, that is for an extension of time, then the register, there's nothing on the register as things stand. The parties will just need an extension of time. That particulars will be delivered along with the court order. You don't need to add the registrar as a defendant in those cases. And in fact, if you have added the registrar as a defendant on the claim form, the court will usually order her removal. Where you do need to add the registrar is where, in those other examples, you've now got incorrect information on the register, which you want to remove. So in those cases, you should add the registrar, serve the claim in draft form on the registrar, and you'll then receive what's called a letter of non-objection, which will state something to the effect that the registrar has no objection to the relief sought, but will not attend the hearing on the basis that they're seeking to save costs. So if there's something incorrect on the register, then you want to add the registrar as a defendant. If you're simply seeking an extension of time, then there's no need to add the registrar. You'll then need a witness statement explaining the error which has arisen, along with any supporting exhibits. And finally, you'll need a statement of solvency from the director of the company with wet ink signature. So this is possibly a little bit anachronistic at this point, but the court tends to require the statement of solvency to be signed within 14 days and with a wet ink signature. So it can't just be a photocopied version of that statement of solvency. So once you've got all of that, you then issue the claim. Some points then for post-issue. So in some cases, these will be listed for a paper determination. If you're lucky, it'll just be determined very promptly on the papers. But in other cases, it'll be listed for a specific date to be determined on the papers. And you'll then need to provide updated solvency evidence dated within 14 days of the date given for the paper determination. In other cases, these will be listed for an in-person hearing. It tends to be a block list on a Tuesday in Central London County Court. What you should do in those cases is deliver the original charge and up-to-date solvency evidence, which means dated within 14 days of the hearing, to your barrister. Those can then be produced at the hearing. Of course, you could file those with the court, but it would be a relatively brave move to consider to do that with Central London County Court. So I would recommend delivering those to your barrister, and those can then be produced at the hearing. There tends to be some divergence in how the judges will approach these matters. So some of them insist on having the original charge and updated solvency evidence. Others, in relation to the charge in particular, are happy to deal with a certified copy. If the original charge has been mislaid or destroyed, then you'll need a certified copy and a witness statement explaining any steps that have been taken to locate the charge and why or outlining that it has been destroyed and is no longer available. So originals, if possible, is the takeaway point here. Post-determination then, as you'll recall, I stated that the court considers that they only have the authority to extend by 21 days from the date of the hearing. So that's a relatively short time when you consider that you'll have the hearing, you'll then need a couple of days to get the sealed order from the court. They are usually quite quick in providing the orders, and indeed they will request that the order, a draft, be sent immediately following the hearing. So you'll hopefully receive it within a couple of days, but you'll then need to get the particulars together and a copy of the order and deliver that to the registrar as soon as possible. You do have 21 days as stated, but one of the reasons an extension is often required is the particulars will be delivered. The registrar will then identify a potential issue after, say, a week or 10 days. You'll then need to address that issue and deliver the particulars all within the 21-day period. So it's, if possible, this should all be done as soon as possible following the hearing to ensure that there's no hiccups along the way, because if the 21 days elapse, again, a new claim will ordinarily be required. So the takeaway point is act promptly. So if you have any questions, please feel free to pop them in the chat. We'll hopefully have time to take some of those at the end, or you can take my email there and I'm happy to discuss any potential issues you might have. So I'll just stop sharing and pass over to you, Alex.
Thanks for that, Rob. Very important provisions to know about, whether you're a commercial solicitor or otherwise. I remember, as you were talking, I remembered a story I'd been told a few years ago about a partner who'd been sacked from a city law firm for different reasons, but after he or she left, they were a commercial property specialist, and it was discovered that in all instances where company charges were involved, that person had failed to register them. So an application to court had to be made for about 600 charges, all at the same time. Obviously, not a position you want to explain to the insurers or anybody else.
Yeah, and that's one of the things people are quite surprised that if that 21-day period elapses, you immediately require a court order. So it's quite onerous, and there is no discretion on the registrar's part to allow late registration.
Right. Very important to know about. And I mean, certainly I used to get a steady trickle of them from my colleagues, so litigators need to know about them too. Right, my half of the talk is going to focus on some common issues that are encountered when terminating contracts, something that you'll be asked to do all the time on behalf of clients, whether as a junior litigator or a transactional commercial solicitor. There are, of course, many different traps and pitfalls, and I'm not going to attempt to cover them all, but I'm going to try and give some insight into what I think, based on my experience, are some of the most common ones that arise and that people fall into. So generally what I'll look at is the extent of the termination rights that may exist in any given case and whether or not they've arisen. Whether in any particular circumstances the right to terminate has lost, the process of actually effecting a termination, and also the effects thereafter of termination, which are often misunderstood. So firstly, assessing the termination rights. To state the blindingly obvious, the starting point is obviously the terms of the contract themselves. Often these are quite elaborate and detailed and may provide for termination for cause, as the American expression goes, or simply termination for convenience. Obviously, in any scenario, even if a party is aggrieved, it's vitally important to check for any long-stop termination provisions which don't require cause to be given, or simple termination for convenience provisions, which are often overlooked but can be very useful without having to demonstrate that the grounds actually exist to justify a termination for cause. One of the commonest type of provisions is that a party may terminate for any breach. I must have seen this dozens of times. They certainly were very popular. They've become slightly less popular, I think, but they're still very common. But they're a very common trap for the unwary. Does any breach literally mean any breach of any term of the contract which requires the other party to do something? Well, depending on the terms of the contract in question, the answer to that is very probably no. So there is a slight tension in the case law, and I've mentioned some of the cases on the slides. At minimum, an any breach provision is likely to be interpreted by the court as excluding trivial or de minimis breaches, but not requiring something material or substantial. One fairly recent authority for that is the Vivian Westwood case that's mentioned on the slide, which is worth reading because it examined some previous authorities as well. So in other words, something merely trivial is unlikely to qualify, but equally you don't have to show materiality or substantial or substantiveness of the breach in question. What that means in any given case is, of course, very fact specific, and to be honest, quite difficult to advise upon. But I've said at the bottom that you should be wary of simply relying on that line of authority, because there are older, and they tend to be higher authorities, that suggest that any breach must mean any repudiatory breach. So in other words, it's possible that the termination for any breach provision may in turn be interpreted as meaning any breach which would justify termination at common law, i.e. be a repudiatory breach. So very important to check the exact wording, and obviously the more specific the wording, then the clearer the party's intention that perhaps even trivial breaches may qualify. Another common provision that is often overlooked, surprisingly often in my experience, is notices to remedy, which are required prior to serving termination notices themselves. So this will be something to the effect that the termination provisions can only be invoked once the innocent party has served a notice of a specified duration, normally to a specified person and in a specified manner, which gives them the option or gives them the opportunity rather to remedy the breach. And very often it's necessary to distinguish, and the clauses themselves may distinguish between remediable and irremediable breaches. Try saying that quickly. So, for example, what does that mean? For example, in the expert clothing case that I've mentioned, the point was whether or not something which had to be done by a certain time was remediable or otherwise. So the temptation to think, there is a temptation to think that if party X has to perform action A by date Y, then once that date has come and gone, that's it. But provided that there is nothing external which prevents or makes it impossible for performance still to occur, it is likely that the breach will be deemed to be curable, remediable. What's the consequence of that? Well, sometimes the clauses invite you to make a distinction between whether or not you serve this prior notice on the basis of whether or not you think the breach can be cured. So it's very important to think about the nature of the obligation that has allegedly not been performed and whether in reality there is anything which prevents it from being performed now. So in the example of deadlines having been missed, can the act in question still physically be performed? It is actually necessary to cure the breach if the innocent party, or well, sorry, the defaulting party wants to avoid the consequences. So in a relatively recent case, a consultant had merely written a letter saying, don't worry guys, I will be performing, and then the contract was later terminated. That did not count as a cure. But it's very important to check for these provisions because very often the proper interpretation will be that if the prior notice to cure has not been served, then that is a condition precedent on serving a termination notice. And so serving a termination notice without one may itself be a repudiatory breach of the contract. The other point to consider is whether common law rights still apply. So in the absence of clear wording, the received wisdom is that both express termination provisions and common law provisions, common law rules, can be exercised at the same time. So in a recent case, the example that was mooted was a clause which provides that this agreement shall commence on 1st of February 2016 and shall continue unless terminated in accordance with this termination clause for X years. So although the decision there was obiter, the High Court judge in question found that, or would have found that, that would be sufficient to exclude termination rights at common law. That's perhaps a surprising decision because at first blush, the clause simply speaks to what has to happen in relation to the termination provisions. It doesn't expressly say, thou shalt not exercise thy common law rights. But it's very important to read the termination provisions as a whole and consider whether or not their intention may be to oust the common law. If there's any doubt, then when exercising the termination notice, of course, the safest thing to do is to rely expressly on the express contractual provisions and also in the alternative to rely upon common law rights. The countervailing position isn't the case, though, so it's not necessary for the contract expressly to preserve the common law rights. What you're simply looking for is whether or not anything in the provisions seeks to exclude them. So what about these rights at common law? Well, obviously, this all sounds like fairly basic stuff, but it's worth reminding ourselves, I think, even though in a way it's first year law student territory. So of course, at common law, there is a distinction between different types of contractual term. On the one hand, there are conditions of a contract, which go to the very root of the contract. In the middle are innominate, or as some of the more recent cases call them, intermediate terms, which are clauses that can tend either way. So they're clauses whose breach can be serious or can be trivial, and the whether or not that is the case dictates the remedies available in response to such a breach. And then at the other end of the spectrum are warranties, which are never capable of forming, or breaches of which are never capable of being repudiatory in character. Now, these distinctions are increasingly of little practical relevance because there's Court of Appeal authority in the case of Grand China Logistics mentioned on the slide, to the effect that most provisions in contracts will be deemed to be innominate terms. Now, there are, of course, many different factors at play when examining the question, one of which is what the parties, if at all, have decided to call these clauses. So sometimes one sees provisions to the effect that clauses X, Y, Z are deemed to be of the essence of the contract or deemed to be fundamental to the contract. And that isn't of itself determinative, but it is a powerful factor, especially in a professionally drawn contract at arm's length, which may indicate what the breach will have the effect of doing. Now, of course, if the clause, as is likely, is an innominate term, then, as I mentioned a minute ago, whether or not any breach of it justifies termination is determined by applying the classic Hong Kong fur shipping test, which is to the effect that the breach must deprive the party substantially all the benefit which the parties intended the party in question to get under the contract. Easily stated, but very difficult in reality, except in perhaps sale of goods cases or very simple supply of services cases to actually identify what that may be. There is a trap for the unwary in all this in relation to the interplay between contractual rights and common law rights, because if the breach in question will trigger a notice to cure under the express provisions of the contract, then it's unlikely that you can simply ignore that and terminate at common law in any event. That was argued unsuccessfully in the Court of Appeal in the Maurice McNeill case that's mentioned in the final bullet point. Now, of course, termination doesn't have to just be for breach. It can also be for what's traditionally called renunciation, which is simply acts or words which amount to a refusal to perform or give rise to or communicate an intention on behalf of a party not to perform its obligations under the contract in the future. That's obviously different from the scenario where effectively both parties have lost any enthusiasm for their bargain and abandoned their obligations. That doesn't amount to a renunciation, and neither does mere inactivity, especially where the contract doesn't provide for certain dates for performance of certain obligations. So renunciations are fairly rare in my experience in practice, but they do sometimes arise, and it's important if you're faced with a client whose counterparty is showing little enthusiasm for the contract that they've entered, to consider whether or not that may be an alternative option. Because as I say at the top of the slide, a renunciation, if properly made out, is also repudiatory in character. Another common scenario, which is usually catered for expressly in termination provisions, is termination by reason of the insolvency of the other party. Now, there's no default common law right to terminate just because your counterparty has entered an insolvency scenario. So that is why there tend to be fairly detailed provisions following a standard form, which refer to liquidation, but also administration and various forms of CVA and arrangement and so on. But again, there is a relatively recent introduction to the Insolvency Act. I think it came in the coronavirus era, which relates to corporate customers, whether of goods or non-financial services, who gain some protection by Section 233B of the Insolvency Act, where termination provisions in contracts cannot be exercised by the provider of the goods or the services. So it's always important to check that in dealing with any scenario. Of course, by contrast, although it's not a topic for today, an insolvency office holder may often terminate a contract depending on the circumstances. Another common scenario that is encountered is whether or not a contract can simply be terminated by providing reasonable notice. Now, the only way to do so, absent obviously an express provision to that effect, is to imply a term to that effect. And there is a line of authority that suggests that that can be done, but of course it depends upon what the express terms of the contract actually say. So, for example, in a fixed term contract, for a contract of a fixed duration, then the court will very rarely at all be persuaded to imply a term which allows for this. This argument is quite frequently run, often unsuccessfully, including as recently as last year in the Burke Partnership case, where a 5-year term, which was capable of being terminated without cause, left no scope for the implication of a right to terminate simply on reasonable notice. But where you have an open-ended agreement, then the court will be more ready to imply such a term, because the inference will be that, objectively speaking, the parties cannot have intended that their contract go on indefinitely into the future. Where that is the case, of course, there is then always a bun fight over what reasonable notice means, and the case law on that suggests that it depends upon the context of the contract and the usual term of notice that would be expected by parties in a similar industry or scenario. So it can be very difficult to actually work out what period of notice should be given in that scenario. In that case, it is usually better, obviously, to provide a more generous period of notice for obvious reasons. One thing that I've mentioned here, which is slightly an aside, but is relevant, is to beware of the effects of contractual estoppel. And I put estoppel in inverted commas because really contractual estoppel isn't an estoppel at all. And the leading cases on this are, of course, PK, Intermark, and Springwell Navigation. And I think one scenario that I encountered in practice is a good illustration of what I mean by this. So I was once acting for a hire company which bailed some goods under a hire purchase agreement. And the goods in question were giant trampolines to be installed in a giant trampoline park. And these trampolines were so giant that they had to be attached physically to the premises, and those premises were subject of a lease. And so the argument by the innovative bailee under the agreement was, well, in fact, actually, you're not the hirer under this agreement at all. You have no title to this agreement. You never hired me any goods, because the moment they were installed into the premises by being physically attached, they became landlord's fixtures and fittings, and so therefore were within the ownership of the landlord of the premises. And so ergo, therefore, we had no right to enforce non-payment under the agreement, and they purported to terminate. Unsurprisingly, the answer to that was you cannot do that, because the agreement in question contained a series of provisions which presuppose the fact that my client, the hirer, was the owner of the goods for all purposes. Even if that is legally wrong, the fact of that doesn't give rise to any kind of termination rights and so on, because the parties are generally, absent fraud, entitled to agree that any state of affairs exists, whether as a matter of fact or law, and they will be bound by that agreement as a matter of contractual estoppel. I say it's not really an estoppel because in reality it's just giving effect to the terms which they have agreed. But it's useful to bear that in mind, just in case you get an innovative argument like the one we had in the case I've mentioned. So once you've assessed the contractual and common law rights of termination, the next thing to look at, in my view, is whether or not those rights may have been lost for any reason. The commonest way those rights are lost are, of course, by waiver. Now, when we talk about waiver here, it's important to distinguish between two different concepts. The first is waiver by election, and the second is waiver by estoppel. When we're talking here about whether or not to terminate a contract, we're dealing with the former, waiver by election, not waiver by estoppel. And they are two different doctrines with different elements and requirements. So it's important to keep them separate. And what do we mean by election? Well, that is, of course, simply the choice between keeping the contract alive on the one hand and accepting the repudiatory breach and terminating it on the other. Once the choice has been communicated, then obviously that can't be undone unless your counterparty is prepared to enter into some kind of agreement to that effect. But the default position is once you've elected, you can't unelect. In order to make an election, the party in question must be aware of his right to terminate. That includes not just the factual elements that justify termination, but also he or it must be cognizant of its right to terminate as well. And election itself requires some form of representation or conduct which is outwardly communicated to the counterparty. And in general terms, any statement or conduct which is only consistent with the continuing existence of the contract, or on the other hand, with its termination, will be sufficient to constitute an election. So, for example, if you go on making staged payments that are due under a contract, despite knowing of a breach by the counterparty, it will be argued against you that the continuation of payments is only consistent with the continuing existence of the contract, and therefore you have in substance made your election. By contrast, simple inaction for a short period of time, or allowing time to the counterparty to perform, or even going further and pressing for performance, provided it's for a short period, is usually insufficient to amount to a waiver. Preserving the right to terminate can help as well, but it's not absolute, and that was confirmed. It's been confirmed in other cases, but there's a recent case of Lombard North and European Skyjets, which discusses the point. So the way that is usually done is, of course, by setting out the breaches and saying that this constitutes a repudiatory breach. We're not terminating now, but we're preserving all of our rights under the contract should you not perform by X date. Usually that should be safe, but of course, if you get a client who has sent a series of angry emails to its counterparty demanding performance, then the more the client has pressed, then the likelier it will be that it has exercised an election. In addition, the following by the case law has been held to amount to a waiver. So calling for further performance, not insisting on performance that's not been rendered, but calling for other performance, for example, deliveries of other shipments due under an umbrella supply agreement or sale of goods agreement, will usually amount to a waiver. Asserting rights to payments which will only arise if the contract has been affirmed, in other words, if it continues to exist, will also do the job. But also continuing to perform your own obligations. As I say, continuing to make payments is the archetypic example, but also pursuing litigation or taking any kind of arbitration proceedings without taking the point will, of course, be an election in and of itself. Very often, boilerplate clauses include no waiver provisions. Now, these are usually only sufficient to prevent inaction amounting to a waiver. So the way they often go is they're structured to say that any inaction or forbearance or indulgence that's given to the other party will not give rise to a waiver. But you've got to be aware of the limits of those clauses. Normally, they do not cure positive acts or statements. So in my example, a clause like that, depending, of course, on its wording, will not save you if you've been continually making payment after the breach has occurred and you became aware of it. And indeed, these clauses have to be treated with a fairly strong pair of tongs to begin with, because there is authority, again, depending on the wording, that clauses such as this may not cover waiver by election at all. They may only cover waiver by estoppel, which relates to other rights which don't justify termination. So then we come to actually affecting the termination itself. Now, again, a statement of the obvious, that it's one that's often ignored, is to comply with the notice provisions to the letter. In the event that you are faced, as is often the case with a client who has purported to terminate using their own notice, you may have to delve into the question about whether or not their notice can be saved. And those who are familiar with property litigation will have heard more regularly of the Manai principle, but it applies to commercial contracts as well. And that is simply the principle to the effect that minor defects in unilateral notices, such as termination notices, won't invalidate that notice, provided that the reasonable recipient isn't misled effectively and understands the purpose of the notice. Now, it's tempting to drop that principle out to cure any defect, but in reality, one has to look at a two-stage process in applying the Manai principle. So the first stage is to consider the proper interpretation of the notice. And the second stage is to match up the notice against the relevant requirements of the contract. Sorry, it says of the notice there, it should say of the contract. So Manai is only relevant to stage one, considering the construction of the notice, not to stage two. So stage two is the, if you think back to your law days, the blue paper, pink paper point. So as the House of Lords said in Manai, if the contract says that termination notice has to be sent on pink paper and you send it on blue paper, it will be invalid. Of course, when effecting termination, it's also very sensible to state the grounds for doing so, although curiously at common law, there is no actual requirement to do that. And indeed, at common law, there is authority to the effect that even if it transpires that you give the wrong grounds for termination, but there were other grounds available which would have been good grounds had you spelt them out, that can, depending on the circumstances, cure your invalid notice. But obviously you want to be avoiding that at all costs. And in relation to express termination provisions, you will normally be required to spell them out in detail. The other important thing to check is the methods of transmission of the notice. Very often you will be required, as I said a minute ago, to send the notice to a particular person, often via particular means. But the commonest trap of all, usually encountered or fallen into by people who are trying to argue against termination having been valid, is to argue that a provision that says thou shalt do something means that you must do something. There is clear authority to the effect that the word shall doesn't mean must. So therefore, if the notice provision says the notice shall be sent to Ed and Barbara, but you send it to Steve and James, that it doesn't necessarily mean that it's invalid, provided that effective notice has been communicated. And of course, the notice has to be clear and unequivocal in order for that to hold true. So just finally, because we're running out of some time, to the effects of termination. So very often, even in High Court decisions and above, you will see it's stated that the effect of terminating a contract is the rescission of that contract. It is not anything of the kind, and there's a section on Chitty which rails against these decisions and explains the difference. So rescission means usually that the contract is unravelled from the beginning as though it never existed. It can be a remedy, for example, in relation to misrepresentation. The effect, by contrast, of termination at common law is simply prospective, by which I mean that termination will only affect rights which accrue in the future. So the usual effect is that primary rights which have to be performed in the future will be, the parties will be discharged from those, so making payment or providing goods or services or whatever. By contrast, secondary obligations will usually survive. And by secondary, I mean things that are ancillary to the contract, because the point is that the contract does survive in some form. It's just that certain obligations under it don't. There may also be survivorship provisions in the contract itself, which state that clauses X and Y will survive termination and so on. Things like confidentiality provisions are classic secondary obligations. But this can have all sorts of consequences if you get the point wrong. So, for example, demanding all sums that have been paid to date under the contract. Well, your remedy following a successful termination will usually be to claim damages, but claiming sums that you've already paid doesn't necessarily fall within that. And it's a very common mistake that people make all of the time. So it's vital to appreciate that it's only prospective in nature. It doesn't act as though the contract never had existed. Thank you all very much for joining, and I hope it was useful.
Yeah, have a good afternoon, everyone.
Take care.